Alec Baldwin's motion to dismiss raises serious legal issues, makes serious legal arguments that are supported by binding legal precedents, and carries serious legal consequences, not only for Alec Baldwin, but for all New Mexico citizens, or I guess anybody who might shoot a cinematographer in New Mexico. The motion, therefore, deserved a serious response addressing Baldwin's arguments about the state's misconduct in the grand jury proceeding. Instead, the state responded with a 32-page Jeremiad against Baldwin and his lawyers that does not cite a single legal decision, does not distinguish Baldwin's authorities, and spends no more than 5 pages addressing the core legal issues raised in Baldwin's motion. So, before I dive into this, one thing you have to understand is that all the legal arguments raised by the defense team in support of their position that the grand jury indictment should be dismissed, they're all legally irrelevant. They're all talking about facts and law that are not relevant to the criminal charge of involuntary manslaughter under New Mexico law. They claim it's relevant. They claim it's relevant to New Mexico involuntary manslaughter, but it's facially not. So they say that the state didn't respond to their legal arguments and their evidence. Well, the state doesn't have to respond to arguments and evidence that are legally irrelevant. That would be silly. That would be like going into a plumbing supply store and discovering that everything on the shelves consists of oranges and fruit and other apples. Is it really a plumbing supply store? No, obviously not. Continuing, this fact bears repeating. The state does not cite a single legal decision in its entire brief, literally. Well, it doesn't have to argue against legally irrelevant arguments or citations. A legal brief without any legal authority is not worth the paper it's written on. Unfortunately, this is no surprise for Special Prosecutor Carrie Morrissey. Prosecuting Alec Baldwin has never been about the law. It is, in her words, about using the justice system to humble an arrogant celebrity that she dislikes. This is the defense quoting that anonymous news article. There's zero evidence that Carrie Morrissey said any of this. The state's opposition to the defense motion to dismiss the grand jury should be rejected, and Baldwin's motion to dismiss the grand jury indictment should be granted. The state claims in a brief devoid of legal authority that Baldwin's motion is just an attempt to ensure that the case is not heard on its merits and to discredit the prosecution so that a conviction becomes unlikely for reasons that have nothing to do with Mr. Baldwin's criminal culpability under New Mexico law. The state has it backwards. The state's own misconduct, 2 years worth and counting, has discredited the prosecution. So they're referring here to alleged misconduct by the first set of prosecutors in securing the first indictment. All of that's irrelevant because those prosecutors resigned and that indictment was dismissed. No harm. What they're obliged to deal with now is the new prosecutors and the new indictment. And the only allegations of misconduct is that the prosecution didn't do the defense's job for it. Didn't share a bunch of irrelevant evidence and legal argument with the grand jury, which of course it's not obliged to do. Continuing, and the state's entire approach to the grand jury proceeding was designed to prevent the grand jury from hearing the case on the merits. Is that true? Just because the grand jury wasn't presented with a bunch of irrelevant evidence and legal argument doesn't mean it didn't hear the case on the merits, because irrelevant evidence and legal argument are not meritorious. The state elicited false testimony from its own experts to secure Baldwin's indictment, only to elicit the opposite testimony from the same witnesses a few weeks later at the trial of Hannah Gutierrez-Reed. They made numerous statements in Gutierrez-Reed's trial that contradict the premise of the state's presentation to the Baldwin grand jury They violated the court's order on how to conduct a fair and impartial grand jury proceeding, including by refusing to contact witnesses that had information favorable to Baldwin's defense and withholding critical information from the grand jury. They read inaccurate jury instructions to the grand jury and diverted its own witness testimony and the grand jury away from the exculpatory evidence. The list goes on and on. This whole list is utter garbage, folks. So, the state elicited false testimony from its own experts, only to elicit opposite testimony from the same witnesses. This is only false testimony if you view it through the biased lens of the defense. The defense believes that if Hannah Gutierrez-Reed was responsible for safety of the gun, that Baldwin could not have had any responsibility for safety with the gun. But that's not true. They're living in Delusionville. So it's not false to say that Baldwin had responsibility just because you also say that Gutierrez had responsibility. Let's see. The state made numerous statements in Gutierrez's trial that contradict the premise of the state's presentation to the Baldwin grand jury. Again, this is because the defense wants to believe that if Gutierrez was criminally liable, that Baldwin could not have been. That's not the law. The state violated the court's order on how to conduct a fair and impartial grand jury proceeding. This is based on the claim by the defense that the court had ordered the state to present the grand jury with all relevant exculpatory evidence. The state did that. But the defense would like you to believe that a bunch of evidence that's not relevant should also have been presented. The court never ordered the state to do that. The court would never order the state to present irrelevant evidence to the grand jury. That wouldn't make any sense. Including by refusing to contact witnesses that had information favorable to Baldwin's defense. It's favorable. Now they're talking about things like how David Halls felt Baldwin should not be held accountable, how Joel Souza felt that Baldwin should not be held accountable, how the screenwriter described the shooting as an accident to 911. That may be favorable to Baldwin on an emotional sense, but it's not legally relevant. It's not part of the jury instructions in this case. Speaking of which, the state read inaccurate jury instructions to the grand jury. That's just facially untrue. Facially untrue, as we've already discussed. And the state diverted its own witness testimony and the grand jury away from the exculpatory evidence. Again, folks, it's not enough that you describe evidence as exculpatory. It has to be relevant exculpatory evidence. In other words, it is relevant to a material factor claim in the grand jury instruction. And the defense, quote unquote, exculpatory evidence is not relevant to anything in the jury instruction for involuntary manslaughter. Continuing, and in the sludge of defamation that permeates the state's brief, their response to the motion to dismiss the indictment, Special Prosecutor Morrissey now makes the stunning admission that her decision to rescind Baldwin's plea offer and pursue an indictment had nothing to do with the facts of the case. Rather, it was based on her mistaken assumption that Baldwin commissioned a documentary film about Rust. Actually, Morrissey had several grounds for rescinding the plea offer she made to Baldwin. The big one, the one you notice the defense doesn't mention here, is that the defense discussed the plea motion publicly with the media. Well, there's an obligation of confidentiality when plea negotiations are taking place. And if the defense violates that duty of confidentiality, the state's perfectly within its authority to withdraw the plea offer, which is what happened here. Continuing, the state violated the U.S. and New Mexico constitutions. That's arguably true, but that would have been the first prosecutors in the first indictment, which has been dismissed, so it's irrelevant. Violated the rules of ethics and the most basic prosecutorial norms. Well, who's to say what the norms are in New Mexico criminal court? New Mexico prosecutors or Manhattan civil litigation attorneys? Violated the laws that apply to grand jury proceedings in New Mexico. That's just not true. violated the court's orders, just not true, misled grand jurors and the grand jury judge, just not true, and elicited false testimony from its witnesses. Again, not true. The false testimony claim is, again, the defense position that if Guterres was criminally liable, Baldwin cannot have been. That's not the law. All this other stuff is the defense complaining that this giant pool of favorable exculpatory evidence that we wanted presented to the grand jury was not presented to the grand jury. Well, it only needs to be presented if it's relevant, and it wasn't. And indeed, it doesn't need to be presented. The state has no obligation to present the defense argument to the grand jury and evidence. They need to make it available to the grand jury. They need to make the grand jury aware that it's available for their consideration. And the state did that here.